Good afternoon. My name is Major Scott Goebel, and I currently serve as the Chief of Strategic Communications for the Office of the Judge Advocate General. Prior to this assignment, I had the opportunity to practice criminal law in both state and federal court as a defense attorney in Texas. Since joining the Army, I've had the opportunity to practice both in and outside of criminal law. Focusing on some of the justice assignments I've had, I've served as a NATO trial observer in Germany, a military magistrate. I was also a prosecutor for 21st TSC before moving to Fort Hood. When I arrived at Fort Hood, I was a senior special assistant U.S. attorney, and then eventually I moved to be the senior prosecutor for 3 Corps and Fort Hood. After Fort Hood, I deployed to Afghanistan and then returned to justice and spent a couple years in D.C. and at the Government Appellate Division. During my next assignment after completing my LLM, I served as a managing military magistrate in Hawaii, and then I served as the Chief of Justice for the Military District of Washington. And today I have the honor of hosting this panel comprised of true military justice experts and practitioners. Today's panel is called Military Justice, Learning and Leading, Changing the American Criminal Justice. If the events of the past year have shown us anything, is that we need to rethink the way that justice works across our nation. And the military is no different. As the Judge Advocate General of the Army, General Petey, often says, you don't have to be sick to be better. And in that light, the military has made significant changes over the last 20 years, and in many ways attempting to emulate or keep pace with civilian jurisdictions, and in other ways, being more progressive. Our hope today is that we can explain and demystify the military justice system and answer your questions that you may have and engage in a dialogue about it. To that end, each panel member will present a brief presentation in the area of their expertise, and then we'll open it up to that conversation and discussion of any issues of your interest. But before that dialogue begins, I want to turn it over to the panel to introduce themselves and explain some of their background and why they're here today. After that, each panel member will present their information, and then I'll open it up for questions and answers. To facilitate the questions and answers, if you can type them in your chat box, I will be able to read them to the panel or be able to call on you directly. Thanks again for joining us and for sharing your time with us. So without further ado, Lieutenant Colonel Farrell, please lead the way.
Good afternoon, everyone. I am Lieutenant Colonel Rebecca Farrell. I am currently the chair of the Criminal Law Department at the Judge Advocate General's Legal Center and School in Charlottesville, Virginia. I guess you could say that I have done justice most of my adult life. I started out at 19 as a paralegal in a county attorney's office, where I thought to myself, I think I could do that. Maybe I'll be a lawyer later. I also worked there as a victim advocate for several years. And then after graduating from law school, I prosecuted for a county attorney's office, as well as while I was in law school, I served as a federal clerk for the Kansas federal court system. And I did that for a year before joining the Army. Once I came into the Army, I have been a trial counsel, which is our version of a prosecutor, a senior trial counsel, a defense counsel, a senior defense counsel. And then I taught here at the school for 3 years, teaching evidence and confrontation. Following that, I was a special victim prosecutor at Fort Campbell at the 101st Airborne Division for 3 years. And then I, of course, as any officer, I've dabbled a little bit in other areas for about a year and a half of my almost 18 years in the Army. And I've deployed twice, both times as a deputy staff judge advocate, once to Africa and then once to Iraq. And then I'm back here at the school again, teaching criminal law and leading the criminal law department. And I will be followed for an introduction by Colonel Lance Hamilton.
Good afternoon, everyone. Yes, I am Lance Hamilton. I'm currently the chief of the Army Special Victims Counsel program. I've been in the military for almost 25 years. I'm a graduate of Penn State University and Yale Law School. Prior to joining the military, I served as a clerk on the 11th Circuit for the then senior judge, Paul H. Roney. After that, I joined the law firm of Holland & Knight Worked for them for several years before joining the military. Since joining the military, I've held many jobs: legal assistance attorney, trial counsel, special assistant U.S. attorney, handling misdemeanor cases, later felony cases, still as a special assistant U.S. attorney. I've served as a deputy staff judge advocate. I've served as a staff judge advocate on 2 separate occasions. I've been stationed in numerous places, including Germany, where I served as the Army's chief of the claim service for Europe. I've also I was deployed to Iraq, as well as spent 2 years in Korea as a staff judge advocate for 2nd Infantry Division. And I will be followed by Lieutenant Colonel Phil Staton.
Good afternoon, everyone, ladies and gentlemen. Hope you can see me. My name is Lieutenant Colonel Phillip Staton, and I am the Chief of the Trial Counsel Assistance Program. When I joined the military service, some of my duty assignments have included being a legal assistance attorney, followed by being a brigade judge advocate for 2nd Brigade, 4th Infantry Division out of Fort Hood, Texas. Deployed with that division, OIF 1 to Iraq for a year. Came back, and subsequent assignments have included being a chief of military justice and a special assistant United States attorney. In addition, after that, additional assignments within military justice have included being a special victim prosecutor, as well as working at our government appellate division, handling appellate cases representing the United States government. I'll talk a little bit more later in my presentation about the Special Victim Prosecutor Program and what that entails. I deployed 2 additional times to Iraq in various operational positions. Following those assignments, additional jobs included being a deputy staff judge advocate at the Fire Center of Excellence at Fort Sill, as well as the staff judge advocate at the National Training Center and Fort Irwin. And I've been in the Army now a little over 19 years. And I very much look forward to our discussion. Following that, now I'll be followed by Lieutenant Colonel Angela Swilly.
Good afternoon. My name is Lieutenant Colonel Angela Swilly, and I currently serve as the Deputy Chief for the U.S. Army Defense Appellate Division, where I'm responsible for managing and training approximately 25 active duty and reserve defense appellate attorneys who represent soldiers in court-martial appeals before the Army Court of Criminal Appeals, the Court of Appeals for the Armed Forces, and the United States Supreme Court. I'm a direct commissionee into the Army straight out of law school, but I've practiced at every level of the military justice system. I started out as a trial counsel or prosecutor at the 3rd Infantry Division at Fort Stewart, and then as a trial defense counsel at Fort Leavenworth, Kansas. I then spent a year in Afghanistan with the 1st Cavalry Division as the senior prosecutor for Combined Joint Task Force 1, where I managed and investigated, or the investigation and prosecution of military justice cases throughout the Eastern region, and had the opportunity to travel throughout the region to train Army Criminal Investigation Division agents on the 2012 changes to Article 120 of the UCMJ. After redeployment, I returned to Fort Hood, again as the senior trial counsel, and then as the chief of military justice for the 1st Cavalry Division. Following my year in Charlottesville for my LLM, I served at the U.S. Army Litigation Division, where I represented the Army in litigation involving military personnel matters, including habeas corpus petitions. Among those, I represented the Army in the habeas corpus petition of Capitol inmate Ronald Gray. After leaving Litigation Division, I returned to Fort Stewart, Georgia, where I served as the Chief of Administrative and Civil Law, the Managing Military Magistrate, and a Brigade Judge Advocate for the 3rd Infantry Division Artillery. I arrived a little over a year ago, or almost 2 years ago now, at Defense Appellate Division, where I spent my first year as a branch chief, managing a team of 4 active duty attorneys and 10 reserve attorneys, and getting the opportunity to represent a few individual soldiers on my own. So I'm going to turn that over. That's me. Turn this over to Lieutenant Colonel Adam Kazin.
Thank you, Angie. Good afternoon, everyone. My name is Lieutenant Colonel Adam Kazin. I am currently the Deputy Chief of the Office of the Judge Advocate General's Criminal Law Division, which is basically the advisor to the Judge Advocate General and to Army senior leadership on all matters concerning criminal law. Like many, I'm a self-confessed military justice nerd on this group, so you're going to get a lot of people who have a passion for military justice, and we've developed that over years of experience. Mine is fairly similar. I've had 19 years in the Army as a direct commission. I spent a vast majority of that doing military justice. After a brief start in my career as a claims attorney, I went directly to Iraq as a trial counsel for a few months, came back, and then most of my initial time was spent as a special assistant U.S. attorney for the Eastern District of North Carolina, trying cases out of Fort Bragg, North Carolina. Essentially, we're loaned out as special assistant U.S. attorneys for all the civilians that commit offenses. So prosecuting both misdemeanor and felony cases in the Eastern District. I went from there directly to Korea. That was my reward, was to go to Korea for a year to be a trial counsel, where I prosecuted cases out of the 2nd Infantry Division. And decided I liked military justice so much, I moved on to the Government Appellate Division, where I spent 5 years at the Government Appellate Division. 2 years, and with the Trial Counsel Assistance Program, 2 years as a line action attorney doing appeals, a year as the senior litigation attorney for both TCAP and GAD, and then 2 years as a branch chief at GAD doing primarily government appeals and capital litigation. So some of the cases that Lieutenant Colonel Phillip was talking about on the defense side, I was working on the government side. After my 60 some odd months at GAD, I moved on to the grad course, and after that, served as a brigade judge advocate, and then another year of school before I went to be a regional defense counsel for the Southeast region out of Fort Bragg. Also, that's supervising approximately 25 defense counsel from across the southeastern United States, defending cases ranging from simple, minor misconduct all the way through murder cases that we were responsible for. And then, of course, I had my own crop of clients as well that I would advise. So 2 years on the defense side before deploying again to Kuwait as the Deputy Staff Judge Advocate for U.S. Army Central. And then back to my true love of crim law. I came to the OTJAG crim law as the branch chief for policy division, doing policy work. I did that for 2 years and then fleeted up this last year as the deputy. Pleasure to be here and share military justice experience. I'll go ahead and turn it over to Scott.
Sir, thank you. And with that, we get to the meat of the CLE portion of it, where we'll go through the substance of and explain some of the various areas where we practice. So, ma'am, I'm going to turn it back over to you to lead the way.
Thanks, Scott. So what I plan to do is just, as soon as I unfreeze, is just do a quick walkthrough of the military justice system and how it works. And then I'll move into discussing what we do at the Judge Advocate General School, which I will call the JAG School, here in Charlottesville, Virginia. So a little bit of background about the military justice system. We evolved over time. When the military justice system first existed, it was long before there was a manual for courts martial, which is the manual that we use that contains all of our procedural rules, the rules of evidence, all of our punitive articles. Before that existed in 1950, and thinking back even 100 more years, it was more of a pure discipline system. You can certainly read any historical book that talks about punishment in the military long ago, and you will absolutely identify right away that it was a discipline-focused system. And there were pros and cons to that system. Obviously, it was very swift, it was very cheap, and it definitely encouraged immediate compliance. But of course, there were cons to that system too. Due process has evolved greatly in the last 50 years, let alone 150 years. And when we didn't have a justice-focused system, we would see innocent soldiers and sailors, Marines, airmen, when each of those services came about, being convicted. We would also see arbitrary punishments. In 1950, we published the first true manual for courts-martial. Prior to that, we relied on the Articles of War and shifted the focus of the system to a justice-based system, just like in the civilian systems, both state and federal. And of course, the pros to that are very much towards due process and fairness, promoting individual responsibility of our soldiers and loyalty to the United States and the Constitution. We established all the standards of proof, mirroring the justice systems in the civilian world. Of course, those systems come with cons that we all feel the pain of sometimes. It's an expensive system to run, and due process takes time. Cases go a lot slower when you make sure that due process is carried out for everyone involved in the case. Operational impacts is something that is unique to our justice system. Because our mission is to fight and win the nation's wars, but we're also running a justice system. Running that system absolutely can have an impact on the operations of the Army. When soldiers are pulled from formations, when we pull in panel members, which are our juries, those people are now taken out of the formation to operate in the justice system. But obviously, on balance, this is the right answer. And our system, just like the civilian system, is a justice-based system. Next slide, please. So in the military, we have more than just courts-martials, more than just trials. And the reason is because even though we are a justice system, when you look at the court-martial process and all of the due process that's incorporated there, we also have the responsibility, commanders have the responsibility of ensuring good order and discipline among our ranks. So they have sets of tools below taking a soldier to trial and trying to convict them of an offense. And those punishments carry the same things that you would see in the civilian world, prison time, but we also have reduction of rank and forfeiture of pay, as well as discharges from the Army. But when we're looking at minor offenses, the kind of offenses that you would think, well, this could really erode the discipline in the unit. Let's say people are late all the time. People don't show up for work, or people go AWOL and they leave and disappear and we don't know where they are. Or when we have other minor offenses, commanders have these other tools below the level of court-martial to deal with those offenses. You can see here on the left of your slide, administrative actions are listed, and there are many of them. The lowest one being an on-the-spot correction. That could be an on-the-spot correction for behavior that is insubordinate. It could be on-the-spot correction for failing to comply with rules or regulation, and there's no paper trail generally created from that. And then it moves down, corrective training. We have all kinds of corrective training for soldiers that need to improve their conduct, and we relate that training to the conduct that they are struggling with. We have formal counseling processes where a leader in their formation will sit them down, do a written counseling to notify them that they are deficient in a certain area and that they need to improve. And then those are followed up with to ensure that they are improving. We also can revoke passes. Just a fun fact is that technically we're not allowed to leave on the weekend. Let's say I wasn't stationed here in Charlottesville and I was on a military base at Fort Bragg, North Carolina. Technically, leaving for the weekend is not a thing. Passes are how we do that. That's how we keep accountability of folks. That's how we know where they're going, how far are they driving. So we could revoke those passes, or we could not give people leave if for some reason they had a misconduct problem. Bars to reenlistment are often used for soldiers that we are separating for misconduct. And so we're not separating them through a trial, but we're doing it through an administrative process. And then we will enter what's called a bar to reenlistment in the system, which means they could never join the military again in any service. And then administrative reprimands are exactly what it sounds like. It is basically a formal letter given to you telling you that your conduct is not acceptable. Those kind of reprimands can go in someone's permanent personnel file, which could prevent someone from being promoted or receiving any other favorable action. And ultimately, usually, if it's in their permanent file, they'll end up having to leave the service because they can't advance. We also have administrative separation. Administrative separation is a process that we do, and the level of due process depends upon the amount of time the soldier has in the service, as well as the discharge that the command wants to give them, an honorable a general under honorable conditions or an other than honorable. Obviously, the more serious and punitive type of discharge is going to have a higher level of due process, having an actual board hear their case, they get to present evidence, they have an attorney assigned to them, and then the government presents evidence as well. And that process we generally use also for patterns of misconduct, a series of things that just show someone can't conform their conduct, or for more minor offenses that don't rise to a courts-martial level. In the middle is non-judicial punishment. You may have heard of it called an Article 15, and there are several different kinds, and those different types are based on both the rank of the officer giving the punishment or giving the Article 15, as well as on the seriousness of the offense. The more serious the offense, the higher rank the person is that's probably going to give that to you, and the more power they have to, for instance, restrict your movement. Maybe you won't be able to leave the base for 45 days. You may lose pay. You could be reduced in rank and have to try to get yourself promoted again. And these really are for minor offenses, and they are a significant piece of that good order and discipline. As you can imagine, many of our soldiers are 18 to 25 years old, and I always like to tell people they're going to make the same silly mistakes that 18 to 25-year-olds make in the civilian world. They just happen to have a job where you could be punished for those mistakes and have to sort of start over. And then on the right, you have courts-martials. And courts-martials are trials. And you have several different levels. A summary court-martial is technically an administrative proceeding. And that proceeding can result in a conviction, but the Supreme Court has said it's an administrative proceeding. So it's not a conviction that you would see on their record later. And it can result in up to 30 days in jail. So again, another good order and discipline tool. We absolutely have had soldiers retained in the service and go on to perform well after summary court-martial, but sometimes they end up leaving the service or we separate them through the administrative separation process. And then we have special courts-martials. We have two different kinds. We have one that is a judge-alone court-martial that deals with offenses 6 months and less of jail time. We generally are going to send lower level offenses there. Those cases can move very quickly. So think of it very much like if you're in a state with classes, it's very much like a Class B misdemeanor trial. And then we have special courts-martials that have panels or juries where the punishment can be longer. It can be up to a year. And then a general court-martial is the one that most people know about because those are the ones you're going to see in the news. You're going to see the media talking about them because that really is what we would consider our felony level trial. That is where we send our most serious offenses. That is where the due process begins with what we call an Article 32 hearing that is very similar to something like a preliminary hearing in a system that has a preliminary hearing in front of a judge and the judge decides whether there's probable cause to then send that case to trial. In our system, the judge decides whether there's probable cause to send that case to the general officer in charge of deciding what goes to trial and write a memo telling him, this is the evidence I saw, this is what I think should happen in this case, whether it should go to trial or whether it should not go to trial. We do have a unique provision called a Chapter 10. Chapter 10 proceeding is what happens when someone is being court-martialed and they say, I would like to get out with a punitive discharge of an administrative nature. So it'll be an other than honorable discharge. And I would like to get out instead of being court-martialed. You'll hear some people call them in lieu of being court-martialed. And we don't see these used a lot, but you absolutely will see them be used more for offenses. Again, think of maybe a more serious military type offense where we weigh and balance the cost of sending this to trial and whether it really should be something that someone deserves a conviction for versus just needs to leave the military, maybe not on good terms. And there are different kinds of discharges you can get at a court-martial. An enlisted soldier can receive a dishonorable discharge or a bad conduct discharge. And there's a small amount of difference between them, generally related to future employment options, as well as benefits through the Veterans Administration when they leave. And then dismissals are simply our version of a dishonorable discharge for an officer that goes to trial. Down at the bottom of the slide, you can see the standards of evidence. So when we're talking about an administrative action, it's preponderance. The rules of evidence don't apply. You can review any evidence you want to make those decisions because it's simply a lower level punishment. In the middle and on the right, the standard is proof beyond a reasonable doubt, just like in the civilian world, and all of the rules of evidence do apply. Next slide. So this is a schematic that we developed at the school to talk about the process of a case moving from start to finish in the justice system. You can see there on the slanted bar that there is a stepping process, and those steps are for commanders. Because commanders are the ones who make the decisions in our system as to whether something will go to trial or won't go to trial. They absolutely have the advice of a legal advisor. Everyone on this panel has been a legal advisor to a commander at some point in some capacity and helped educate them on the law to make this decision and to make recommendations. So you can see the little crime bubble there. And when a crime occurs, it is sent for an investigation. If it is a military type crime or a very low level misdemeanor type crime, it could even be investigated by the command. The command can appoint an investigating officer to try to figure out what happened and then turn that investigation over to the commander to let them know these are the facts so you know what kind of action you want to take. But our more serious offenses, the typical things that you would think of as crimes, so not being insubordinate or not being AWOL, but typical crimes, that's going to go to our law enforcement agencies. We have military police investigators and we have CID. Other services have different names for them, NCIS. So you have the Navy system, you have the Army's Criminal Investigative Division, and they investigate our felony crimes. They're basically our detectives. When they're investigating those crimes, they're talking and working with the prosecutor, just like you would see in the civilian world. And once that investigation reaches a culminating point, it's taken into first, usually the company commander, and then the battalion commander. You can see the next block there, it says SCMCA, which is Summary Court-Martial Convening Authority. A battalion commander has the ability to convene a summary court-martial. We base the ability on your rank as well as the position you hold. On the next block there, you see SPCMCA. That's Special Court-Martial Convening Authority as well, but at the brigade level. So the brigade commander has the ability also to convene a special court-martial, but he can also get the process started for a general court-martial by doing what's in that yellow bubble there, which is setting up the Article 32 hearing. He can appoint an officer to hear the Article 32 and then provide him a report after evidence is presented at the Article 32 hearing. Article 32s, I had mentioned, they have some similarity to preliminary hearings. That is because everyone is there. The accused is there. He's represented by a defense counsel that's appointed for him. The prosecutor is there. And then the Article 32 officer is there as well. They can put on witnesses. They can put on documentary evidence in order for the Article 32 officer to come to a conclusion. Ultimately, for a case to end up at a general court-martial, it has to go to what we call a flag officer, a general officer. And that general officer has to be in command and be designated as a convening authority. When he has that power, he can then take that Article 32 report and the advice of his legal advisor and refer that case to a military judge for trial. Once it gets to the military judge for trial, it's now the military judge's case. The military judge makes all the decisions. Funding still comes from the command, but for justice, it's now in a courtroom with the judge, attorneys talking to the judge about moving the case forward. And up there at the top are our appellate courts. And I'm going to leave that for Lieutenant Colonel Swilley to talk about when she talks about the Defense Appellate Division. Next slide. So as I said, that was an overview of the system. As I said, I work at the JAG school here in Charlottesville. So the JAG school is a place I think that we all love to come, partly because you get to talk with your peers, you get to talk with your colleagues. Just like in the civilian world, you want to bounce ideas off people. There's a lot of networking involved, getting to know people. But we are here to educate the JAG Corps. And that is both the uniformed JAG Corps as well as the civilians that are in our JAG Corps. So we offer several courses throughout the year. I would say our flagship course is the LLM program, We are on the grounds of UVA. We are actually right next door to the UVA School of Law. We have been here since the 1950s, leasing that building. And we joined in that partnership with UVA because we shared resources, and we do still share resources. We share law libraries. Our professors often come over to their school and assist with judging moot court and mock trial competitions. We can go over there and teach. We can have their students attend our classes for credit for law school, because we are an ABA accredited law school. Even though we don't grant the law degree, we grant an LLM degree in military law, and you can specialize in criminal law or cyber law or contracts. So we have several areas you can specialize in if you want to drill down a little further beyond basic overview of military law. We also have our officer basic course come through here 3 times a year, and they're here for about 3 months each time. Those are our brand new lieutenants. Some of them are captains, and they come here to learn military law. They're already licensed attorneys, and they come here to learn not only the law, but also about the Army. And then you can see a list up on the screen there of several other courses we offer. We also teach commanders. Every brigade commander and every general officer comes here to learn from us. Next slide. Sorry, my screen blipped out on me. That's clearly my computer. So what do we do here at the JAG School besides teach? We also do a lot of coordinating with, for instance, Lieutenant Colonel Kazan's division, talking about whether it be a policy issue or a change to law. We'll give input, because just like any other law school, we have the wonderful ability here to really spend time researching and studying, writing, publishing, just like any other law professor would, on a specific subject matter that is your area to be an expert in. So at the school, you're going to, people in the JAG Corps come back here every couple of years to go to short courses based on their specialty. But otherwise, we usually see them at the beginning for a block of time, for a year for their LLM. Everyone must get an LLM in the Army. And then we usually see them towards the end of their career for all of the senior level courses. And that is what I have for you. And I'm going to pass it now to Colonel Lance Hamilton with the Special Victims Program.
Again, good afternoon. Yes, the Army Special Victims Council Program. We're in the Army, we love acronyms, so the SVC program is the way you will hear most people describe it or talk about it. While we are not as big a part of the military justice process as would be the trial counsel or special victims prosecutor, and the prosecutors or the trial defense service, the defense counsel, we are, in my opinion, probably the most vital portion of the military justice process, because we care for and take care of the victims' rights and needs throughout the entire process. That's my plug for the SVC program as being biased, of course. It's a program that's unique to military services. And I believe we are pioneers, because I don't think there's another justice system that provides legal representation to victims and gives the victims and empowers the victims with a voice throughout the process. That's the statutory focus of what it is that the SVC program does. For those of you who may have Navy or Marine, United States Marine Corps friends, they refer to their program as the Victims Legal Counsel Program, but the function and what we do is basically the same. The Army, the Air Force, and the Coast Guard refer to it as the SVC program. The Army's program is about 7.5 years old. And so for Army speak, that's a brand new baby program that is still evolving. And through the years, we keep expanding our scope and doing more and more for victims across the board. We're continually expanding. The Army's program stood up back in October of 2013. And since then, we've expanded from representing active duty soldiers to reserve component soldiers. We expanded to representing dependent children who are victims of alleged sex assault offenses. We've expanded in 2017 to representing DoD civilian employees. And most recently, based on last year's National Defense Authorization Act, we've expanded to providing, or we partner with our legal assistance attorneys to provide legal counsel to victims of domestic violence. Around 2018, because of the demand for special victims counsel across the board, where the Army, through our Judge Advocate General, decided to regionalize to better leverage the Special Victims Counsel expertise within regions. We're broken up into 5 regions: Eastern, Central, Western region, Asia, and Europe. And those, we've appointed regional managers, more senior Special Victims Counsel or majors, and they are responsible for dividing up and ensuring that the Special Victims Counsel within those regions aren't overburdened with cases. They deal with conflict cases, and they also serve as their technical support and supervision backup through the SVC program here at the Pentagon. Not here, obviously, I'm talking to you from home due to teleworking, but in DC at the Pentagon, where we operate and we are headquartered. We've grown to the point where now we are taking on approximately, somewhere over around 2,000 new clients a year through the process. And so that demand keeps growing for what it is that we're doing, which is why we have to continually evolve and push for more Special Victims Counsel to support the demand that's out there. What has been unique through our transition is we have now become more normalized and expected throughout the process, from the trial counsel, the prosecutors, defense counsel, as well as judges, including our criminal investigation division. They now appreciate the value and the role of the Special Victims Counsel throughout the process. While we don't take care of every aspect of the victim or our client's needs, because we're not medical doctors, we're not therapists, we provide them the assets and the understanding as to where they can reach out to those resources. The key to the SBC program is we provide legal representation to the victim. We advocate for the victim throughout the entire process. We give them a voice. We empower them and protect their interests and rights. We do so, we ensure that they have a voice and consult with the trial counsel on a way forward. We ensure that their rights are protected from the accused. We seek that they be present at all available proceedings and things like that. That's what we do on behalf of these victims. While we all, trial counsel, defense, and the investigators, we want justice. Justice for the victim can vary at any given time. And for each case, it may be different. For some, it's a court-martial and a conviction. For others, it's the alternative disposition that you heard Colonel Farrell talk about. For some, it may be an apology. So while we're part of the justice process, we're not for the prosecutors, we're not for the defense, we're not for the investigators, we are for the victim. Slide. RSVC attorneys are handpicked. Each staff judge advocate has to nominate and recommend a judge advocate to become an SVC, having had the chance to observe them over the period of time to ensure that they have the requisite experience, maturity, and professionalism to serve in that capacity, the sensitivities and the need to be empathetic while managing expectations and supporting exactly what the victim needs is vital for SVC. So that handpicking is crucial. They go through specialized training. Colonel Farrell talked about some of that training. We started in our basic course, and we have a 2-week course where they get even more focused training on trauma, the effects of alcohol, on memory, vicarious trauma. They have victims panels and actually mock interviews to understand how to communicate with those who we find will come across at their lowest point in their lives. Most of the time, this may be some folks' first experience engaging a lawyer, and it's unfortunately at this time. Then our Judge Advocate General must certify each individual. Each SBC or potential SBC must also self-certify that they're not under any professional responsibility or investigation or have anything negative in their background. And then the Judge Advocate, they, after being self-certifying, they also have to go through our professional responsibility branch to be cleared before being certified. We don't value judges SBC. We train them not to value. We take the victim as they come in, whether they file a restricted report or an unrestricted report. We provide them the same zealous and competent advocacy to ensure that their voice is heard throughout the process. The launching and the partnering with our legal assistance attorney into the domestic violence world now, where we're providing legal counsel, we enter into dual representation with our legal assistance attorneys who will handle and be responsible for a lot of the, either custody guidance, financial support and things like that. And then they dual represent with us if that case, that's domestic violence case, heads into some type of military justice tribunal, whether it be a court-martial or administrative separation board or an Article 15 proceeding. That's when we co-represent with the legal assistance attorney and provide that victim that voice through the process. So one way to think about the value of the SBC program and the SBC, there was a recent discussion with some senior members, the senior enlisted members who were victims of sexual assault earlier in their careers prior to the implementation of the Special Victims Counsel program. And they said if they had to do it all again, knowing what they know now, they would have never engaged in the process because of the re-victimization they felt throughout the entire process. And then when posed with the question, knowing that there's a Special Victims Counsel out there now protecting your individual interests, would they change their mind? And invariably, they all said, yes, I would still consider it now with the Special Victims Counsel. So with that, I hope that encapsulates a little bit of what it is that we have. I look forward to your questions later, and I will be followed by Lieutenant Colonel Phil Staton.
Good afternoon, everyone. I'm here to talk about with you or share with you a little bit about what's called our Trial Counsel Assistance Program. We love the Army acronyms. We more commonly refer to it as TCAP. You can see there that on the screen first is what our mission is, right? And that is to, develop and administer and maintain basically a comprehensive military justice trial advocacy training curriculum, and develop, that assistance for our military justice practitioners in the field. And you can see there, our end state, or what's our overall goal that we're looking for, providing that training through our mission. And it's basically to have them gain and have the most expertise as much as possible when they're ready through their training to prosecute, let's say, a special victim case, which I'll talk about. And again, with a military nexus, ultimately achieve good order and discipline in our armed forces. I'll talk a little bit more as we go forward within that. Okay, what does that mean and how that kind of applies as we moving forward? The best thing I can kind of connotate within the civilian context is equivalent, perhaps, training programs with experienced prosecutors within the U.S. Attorney's Office, how they conduct their training, or perhaps in a state prosecutor's office to continue equally with what sort of internal training are they getting in terms of the latest case law or latest best practices, or a new prosecutor who's arrived, how to develop their training to maximize their litigation experience and overall effectiveness in the courtroom. Next slide. So within our Trial Counsel Assistance Program, we have what we call 3 coordinated lines of effort that we're trying to get out. The first is we are available 24/7 for availability, and we provide through TCAP, and the next slide will show more about who's there, basically, direct assistance in military and civilian litigation experts that are available to help them in the construction in terms of specific advice throughout the case. And so oftentimes what we get is, in addition to a repository they have that they can email us, obviously different time zones, we're available 24/7. They can call us if they have a court martial going on in Korea, Japan, Germany, Italy, you name it. And the goal is that we may very well have a trial that's ongoing that obviously a question or legal issue has come up, and TCAP is there to help those attorneys or those prosecutors on that case, assisting them with what is coming up at that court, or what they're prepping for, or just anticipating legal issues that they need. And so we do that through 24-hour availability, again, beyond just an email, our phone calls, setting up a similar system like this to be able to talk to them remotely. And it provides a direct advantage, I think, to have that ability for them in terms of the assistance that they may need at a court martial or trial. You can see there also is we have worldwide coverage for our special victim prosecutors. We do have training and experience for our military prosecutors. Currently, we have 29 special victim prosecutors. With them are also special victim non-commissioned officers who are specialized and trained paralegals, as well as a special victim witness liaison, who is a civilian as part of that SVP team to be really that first point of contact for that victim and to ensure that we are enforcing all the rights and protecting the victim in terms of victim care, from the Crime Victim Rights Act to within our Army policies about what the victim should know, the right to be informed continuously throughout the process, the right to be treated with dignity and respect, etc. But we have within that, you can think of a team, an SVP team, who's there worldwide. We have 23, as we say, green suitors or military justice special victim prosecutors, been specially trained, educated, kind of moving forward from what Lieutenant Colonel Farrell just talked about at the schoolhouse, and continuing their training that they've developed through practical experience, vis-a-vis the amount of cases that they've done, to the training that they have conducted, to now have a point where they are recognized to be able to prosecute a special victim case. Per our TJAG policy, a special victim case is any sexual assault or attempted sexual assault on a both adult or child victim, intimate partner domestic violence, as well as child pornography, child endangerment, etc. And so if any investigation comes from the jump, basically, you're going to have a special victim prosecutor and that SVT team working very closely with law enforcement, as we would say, from Genesis forward, in terms of developing potentially an evidence-based prosecution for trial. But I can tell you that they, as we'll talk a little bit more, receive the requisite training and continuous training through TCAP and some of our partners on the civilian side to continue to make sure that they have the most up-to-date information as much as possible. And finally, kind of I touched about on the bottom, is coordinated and efforts there through training and education. We do have a comprehensive and integrated training program that we conduct. And even through adversity in a pandemic, usually every fiscal year, we're constantly looking to have an approved training plan, which we have to execute. And even in this global pandemic, for example, we've continued our remote training, such like this, where they're really in the equivalent practicing as if they were in a courtroom potentially, or talking legal arguments, or conducting training on an agenda with a kind of remote VTC platform capability. And that has proven to be invaluable, especially if we have our challenges, let alone continuing courts martial in a pandemic and ensuring that we're meeting the safety of those in the courtroom, while at the same time understanding that's a pandemic and everybody's safety is paramount. But as everybody knows here, criminal law is continuing in the military justice field, and courts martial continuing. Next slide. So what are some of the resources that we have through the Trial Counsel Assistance Program? Is number one, you can see there are experienced military litigators and complex litigation team. Here, as we say at TCAP Maine, we're stationed out of Fort Belvoir in providing that worldwide support. We have 3 captains who are training officers, as we call, with significant prior military justice experience. We have a complex litigation team, and you can see they're complex litigation experts. We have 2, as we say, green suiters, a major lieutenant colonel, who have significant litigation experience and can apply that worldwide with complex litigation issues that could come up. Everything from pre-trial to a potential writ that would be filed at our appellate court, in response. And I know Colonel Swilley is going to talk a little bit more about the appellate process. But within that context, we have our complex litigators there to provide support. Additionally, we have here 3 special victim litigation experts who are all former civilian prosecutors, one from Cook County, the other one from Fulton County in Atlanta, the third from Connecticut, who have significant prior experience on the civilian side and have been able to bring that effectively to assist our military justice teams. And finally, you can see there, we've got our world-class training partnerships that we do and a support directorate. And some of our partnerships quickly could be within DOD with our Air Force or Navy or Marine Corps partners, as well as the civilian side through discussions and presentations with our civilian side experts on everything from a sexual assault forensic medical examination, a forensic psychologist or psychiatrist, the latest, whatever the law is involved, to get that out to our teams. Now, in all of that, that is the essence of what Trial Counsel Assistance Program, or TCAPS, here that we're trying to do within the Army. I'll be followed now by Lieutenant Colonel Angela Swilley. Thank you very much. I look forward to any questions you may have.
Thank you, Colonel Staton. So Article 70 of the UCMJ requires that the Judge Advocate Generals establish a defense appellate division to provide convicted or soldiers convicted at courts martial with appellate representation before the service courts of appeals and the Court of Appeals for the Armed Forces and the Supreme Court. Likewise, Article 70 requires the same be created for the representative of the United States in the Government Appellate Division. So GAD, DAD, and the military courts comprise the appellate system in the military. And this is probably the part of our military justice process that is most similar to the civilian courts, in that, as you can see, our military courts or appellate courts look very similar to the structures of civilian, both federal and state courts of appeals. Each branch has its own service court of criminal appeals, as you can see there, and then those cases are appealed then to the Court of Appeals for the Armed Forces. And where the Court of Appeals, or where CAF agrees to or decides to consider an issue, that soldier then has the opportunity to request certiorari to the United States Supreme Court. So the active duty, the service courts are actually made up of active duty and reserve judge advocates that serve as the judges on those courts. However, Congress created the Court of Appeals for the Armed Forces to be, quote, completely removed from all military influence and persuasion. So this court is made up of civilian judges appointed by the president and confirmed by the Senate, who to review our cases and who serve as somewhat of a civilian check on our military justice system, or the first civilian check on our military justice system. And although they are similar in structure to the federal courts, the military service courts are courts of statutory jurisdiction, and may only therefore act within those statutory boundaries. So the service courts get their jurisdiction from Article 66 of the UCMJ, which has been described as an 800-pound gorilla because of the statute's mandate that the courts approve only so much of the findings and sentence of a court martial, which are correct in law and fact and should be approved. This means that the service courts of criminal appeals consider the entire record, and they give a fresh and impartial look to the evidence presented at trial, and they can consider the credibility of the witnesses on their own to determine whether or not a conviction and a sentence of a court martial should be affirmed. You can, next slide, please. So another unique aspect of the military appellate process is that a soldier's right to appellate review remains following a guilty plea. So long as the adjudged sentence fits the minimum jurisdictional requirement for that court. So that means, unlike in civilian courts, a guilty plea does not waive appellate review, and defense appellate counsel can, and sometimes do, successfully challenge improper or insufficient pleas of guilty. In defense appellate attorneys, we also get to kind of explore the boundaries of our court's kind of awesome authority. sometimes arguing, we've argued in the past couple of years, the Army court doesn't go far enough. For example, in the last 2 years, Defense Appellate Counsel have argued that the Army court erred where it declined to consider whether a confinement facility's policy improperly increased the appellant's sentence where the policy did not amount to a violation of the Eighth Amendment. Likewise, because the military courts are limited by their statutory jurisdiction, and because Congress has the authority to change the statutes, Congress is able to modify the service courts and the Court of Appeals for the Armed Forces' ability to take action, both by modifying the types of cases that are entitled to review and by designating the standard on which the courts may base or must base their review. Sometimes these changes are for the benefit of a convicted soldier, such as where Congress created an opportunity for soldiers whose sentence do not meet a certain minimum standard to apply for automatic review. Sometimes these changes we found operate to starve the 800-pound gorilla in response to public displeasure. For example, recently, the Army court set aside a sexual assault conviction for factual insufficiency. And shortly thereafter, in the next National Defense Authorization Act, Congress limited or changed the way that the court is permitted to consider cases based on factual sufficiency, somewhat increasing the burden on an appellant to get that case overturned later on. So basically, the military appellate system, much like the appellate system in the civilian courts, really look to serve as a balance of the trial level system and to ensure that in every case that justice is done. Fortunately for our counsel that operate in this system, it creates extra challenges, kind of with the changes in the law and with trying to change the law. We can operate kind of in this interesting place and develop, hopefully for the benefit, of the system overall and those who are, being served by that system. So next, I'll turn it over to Colonel Kazin.
Okay, I'm unmuted. Good. Thank you, everybody. Hopefully I will take not as much time as needed so that we have plenty of time for questions. I see there's lots of good questions coming into the chat room. We want to make sure we have time for that. What you've heard a lot so far is sort of how the system works, what it is on a day-to-day basis operating. My job was really more of a policy area where we look at how the system works and how we might want it to work and how it's changed over time. The first slide that you see, the first bullet you hear, evolution of the system, might be a little bit misleading because the evolution of the system has not just happened since 2005. If you trace the history of the Uniform Code of Military Justice and military justice in general, you see that there are significant changes usually associated with the follow-up to major conflicts. So you see significant changes to the law in the last 100 years following World War I, World War II, Korea, Vietnam, the experiences of large-scale operations where there was large-scale disciplinary actions as well, led to reforms and changes as most of the people that encounter the military justice system then might have gone on to the halls of Congress and realized there needed to be reform. But frankly, 1983, the Military Justice Act 1983, following that, you saw a long period of stability in the law. There certainly were changes throughout it, important changes, but nothing what I would consider seismic changes until you start getting into really the post 9/11 era, and where the changes that have been to the military justice system over the last 15 years have really been driven by concerns about sexual assault and sexual harassment in the military. That has been the driving change in the evolution of the system, at least since I've been a trial counsel when I first came into the military. And so what we're looking at is I threw some dates on there. They're just as arbitrary as anything else, but those are what I consider some significant dates of things that have driven the change. And one of the biggest ones was the creation of the DoD Sexual Assault Prevention and Response Program in 2005, where DoD and all of the services really took a programmatic approach to sexual assault. really in response to survey data that showed a high rate of sexual assault within the military that caused great concern both within the military and through the halls of Congress. And Congress, in their constitutional role as the supervisor of the military, gets a lot of say in how our system evolves. The entire military justice system is built around Congress's power to regulate the armed forces. So, that's really one big change. And then, of course, through trying to figure out better ways to increase reporting, because what they saw is that the prevalence rate, or the rate of people who had claimed in survey data that they were the experience of sexual assault, and the sexual assaults actually being reported, there was a huge gap or gulf in those numbers. And so the idea is we want to get these crimes out of the shadows and pushed into the light of day. And so that the Congress, DOD came up with the restricted reporting option, which is something, again, unique, where the idea was we want to make sure that soldiers who are victims of sexual assault are getting services, the health care, the mental health care they need, even though they might not necessarily want to go into the criminal justice process. Whether it's the military justice system or the civilian justice system, victims tend to report that the criminal justice system is a traumatic experience. Just having to have the worst moment of your life advertised in a public forum for all to hear and all to see is not something any person wants to go through. And it doesn't matter if you're in the military or if you're a civilian, it seems to be pretty universal. So the idea of a restricted reporting option to get those services with not necessarily triggering the criminal justice system. And really between 2004 and 2019, we've seen a lot of activity, congressional activity in this area. I put 180 plus NDA provisions regarding sexual assault in the last 15 years. I saw a recent draft GAO report, which I don't think is public yet, but they had the number at 240. I'm not sure how we're having different, they might count theirs differently than we did, but you can kind of get the idea that there's a huge number of changes to the system that is certainly going to impact how we do business on day to day. The other data I point out there is during this time period, the prevailing theory is that there might be something uniquely wrong with the military justice system. The Invisible War was a documentary that was put out that talked about sexual assault survivors' experiences and negative experiences within the military that generated a lot of attention, again, about victim care, and drove the conversation about what we need to do within the military to better address this issue of sexual assault in the military. So the special victim, this is where the Special Victim Council and initially a program from the Air Force came about. And then what we found is that, over the years of changes, there was concerns that the military justice system, the pieces might not still fit together because there'd been a lot of piecemeal changes. And so the Military Justice Act of 2016 was an effort to make sure that the military justice system was fully integrated with all the changes and all the reforms that they thought were necessary. And so that passes in late 2016, early 2017, but does not go into effect right away because there were so many changes and the implementing regulations that needed to get forward. They delayed the implementation until 2019. I say that because what happened in that intervening period, of course, is what we know as the Metoo Movement. The Metoo Movement actually traces all the way back to 2006. That people would post their Metoo stories on MySpace, if anyone remembers MySpace. The difference in 2017 of how the Metoo movement, what really goes viral, is two things. One is we now have Twitter. We now have social media platforms with instantaneous information. And the other is that it involved a high-profile case. It's really the big one is the Harvey Weinstein case, where suddenly, in a high-profile way, these stories are being shared across really across the country. And it showed, from our point of view, one is that this national conversation about sexual assault is what needed to be happening, and it showed that there was cultural problems that aren't necessarily unique to the military. The military has its own issues and of course concerns, but this is a nationwide cultural problem that may not necessarily go directly to a sort of military solution, but needs a cultural solution. So we start really are having to look at prevention and not necessarily prosecution as the means to get after it. That being said, what really kind of permeates this, and I realize most of the time, and hopefully I'll be able to get to a couple of questions here as I discuss this, is what's gone through this process is really highlights the role of the commander in the system. The military justice system versus the civilian criminal justice system the debate about it seems to go towards the role of the commander, because the role of the commander is something unique and different. And so then it becomes a question of how do they compare? Which is better? What do we want to be more like? What does success look like? What does a successful criminal justice system have? And is there virtue or vice to having non-lawyers in the decision-making process? What I will just quickly say is that before we had this kind of dichotomy, the debate seems to be, well, military justice system is about discipline and civilian criminal justice system is about justice. And I respectfully disagree with that dichotomy, or I've come to disagree with that dichotomy, because what I see is that any punitive sanction of law is designed for discipline, including the civilian criminal justice system. We don't have punitive sanction for crime, is designed to control human behavior. So there is a disciplinary aspect to both justice systems. The main difference is that the military justice system has more conduct that we regulate than the civilians do. And so it's the justice aspect is about ensuring that when we discipline, whether it's disciplining your citizens for driving too fast or committing crimes in the civilian world, or we discipline our military for either military or non-military crimes, the justice aspect is what keeps that process fair within the context of that. And so that's what we look at, is trying to balance ensuring discipline, whether it be criminal, military, or civilian, and ensuring that the system is fair. And with that, I will turn it over to Scott so that we can get to some questions and discussions.
Excellent. Thank you, sir, and thank you, panel members. We're now to the part of the event where we are opening it up for questions. However, before we do that, there's an important announcement I have to make about CLE requirements. The CLE code for this program is MID-CLE 021905. Please write this code down and enter it in the CLE box located under the media player on the section details page. Once again, the CLD code is Mike India Delta -Charlie Lima Echo 021905. You must enter this code in order to get the credit for CLE. Now turning, as the panel member said, the military justice system is just simply part of the American justice system, but designed to ensure a disciplined force. We should not hesitate to ever ask the hard questions or be able to look and acknowledge any deficiencies we have or strengths. As we all know, the Army is not a perfect organization, but it will always be accountable to the public we serve and to the parents who entrust us with their sons and daughters. We now look forward to some great dialogue. We have some great questions already, but so that we can keep learning and keep growing, keep those questions coming. So with that, the first question is from Rayo. Military and ex-military compromised many of the 6th January insurrectionists. What are the current legal actions available to root out those who are white supremacists and take action contrary to the Constitution? Colonel Kazin, I'll hand this one over to you.
Okay, thank you for the question. Yeah, there is certainly a lot of concern right now about the involvement of, as you call, military and ex-military members on the events of January 6th. The options available really go towards the definitions of what we mean by military and ex-military. And I say that because we are a status-based criminal justice system. The ability for the military to take action, or for the Army or the Air Force or anyone to take action, depends almost exclusively on the status of that person on the day they committed the said offense. So when we say ex-military, if someone is fully discharged from the military, they got their DD 214 and they're out of the service, the fact that they once had an affiliation with the military gives us no ability to touch them at all, because they are no longer subject to the military jurisdiction. If they're current military, even then the definitions matter. If they're active duty versus reservist versus National Guard. An active duty person is going to be much easier to discipline because they're subject to the code at all times. A reservist or National Guard is only subject to the code at other times, and such limits our availability to do actions under the UCMJ. And then retirees are an entirely different category. And because some retirees, active duty retirees, those that retire from active duty are still subject to the code, but those that are retired out of the reserves are not. So you have all these different statuses. This is a very long way of saying that we have to approach each case on each individual on a case-by-case basis. First, understanding what their status is, and then understanding what it is that they did at the time. And so not approaching it from a sort of categorical way, but approaching it from a case-by-case basis. And also understanding that we have our civilian law enforcement partners that can also take action on their end. And if someone were to say have a conviction out of that, there might be administrative issues on the back end from us. So it's just you see someone on the TV that's got a uniform on, anyone can buy a uniform, or you see someone that once had affiliation with the military, doesn't necessarily give us license to take action if they are in what we would consider a civilian status. Great question.
Thank you, sir. The next question is from Linda. And Colonel Farrell, I think you'll be in a good position for this one. One of the most interesting distinctions in the military's broad use of what we would call diversion versus the civilian justice system's more limited use. From your experience, what can the civilian system learn from the military experience?
I think from the military experience, and this is really a Colonel Hamilton issue, but I think the SVC program in particular, if I understood your question, we have really ensured that every person who's involved in that case, whether party or not, has a voice in the place they're supposed to have a voice. I also think we have some similarities that, quite honestly, while we may have had them first, I think the concepts are learned from the civilian system as they developed over time. For instance, when I talked about the administrative actions and non-judicial punishment, I know one of the major things that often the paperwork I handled when I was a paralegal at a county attorney's office was for diversions, and it was for non-process. And I think that there are similarities there in looking at there are ways to correct someone's behavior, discipline them, get justice for the victims involved without necessarily going to trial. And I think one thing that the civilian system has really learned from us about doing that are veterans courts, where so many jurisdictions have established veterans courts where there is a process where for first-time offenders or minor offenses or people who I like to think of them as kind of on the fringe, they aren't people who aren't savable. And those programs are programs that can save them rather than putting their life on a path where it's very difficult to come back as a productive member of society.
Thank you, ma'am. The next question is from Holly Cook, and Colonel Hamilton, I think you're in a position to answer this. She says, thank you all for your service in this presentation. Regarding the SVC program, do you know if any civilian jurisdictions are implementing similar programs, or if colleges or universities are using that technique? If so, do you have any idea who's paying for their counsel?
Good afternoon, ma'am. Nice to hear your name. Right now, I am not aware of a civilian jurisdiction doing the same type of program in the SVC program. I know the United States Military Academy coordinates with various universities and discusses these, sorts of aspects. And since we are dealing with the same general age demographic, 18 to 24-year-olds that are sort of in that revolving cycle of sexual assault misconduct, that would be something that we could leverage between the civilian universities. However, right now I'm not aware of it. And as far as the funding source, especially if it went to the civilian sector, I have no idea on that. Right now, we are sourced from the headquarters up here at the SVC program office, and we fund all of the training, all of the TDY travel, travel for our victims worldwide, not our victims, our SVC worldwide to courts martial and things like that on behalf of their client victims. So that's where the funding piece comes in right now. But as far as the universities, I think that's something that could be explored.
The next question is for Colonel Staton. This is from Brian Cox. One suggestion for military justice reform is to create a department of judge advocates who specialize in sexual assault prosecutions and perform that role for their entire career. Do you get a sense that TCAP structure adamantly complements trial counsel in the field such that this suggested reform is unnecessary or redundant?
Mr. Cox, thank you for the question, and an excellent question. I can tell you it's one that we are continually looking at. I can tell you offhand that it's a balance, I can tell you for some, between wanting to continue to do what they love, such as those that are on the panel right now in military justice and being a career prosecutor, if you will, and staying in that field versus obviously getting exposure to differing fields and particularly with transparency, wanting to continue to get promoted and the promotion boards knowing that, okay, why is this person in this position for such a long period of time, as opposed to a normal PCS cycle of every 2 or 3 years. But with that said, it's something that I can tell you that we're looking at, and something that if we do is one question is, what does that structure look like? Because that would be very different. Right now, you know, again, we're scattered throughout the globe, our prosecutors, and they're doing great things. There's a volume there, though, that's admittedly challenging. But it's one that, hey, if you have sort of our prosecutors that are, let's say, captains or majors who have military justice experience, if they stay in that field and continue to develop, do we need additional prosecutors? Do we stay with the ones that we have to further develop and become career prosecutors, if you will? So it's one that is kind of a balance between what I've discussed here. And it's one that you kind of have to take a step back, and it sounds great, but there's other kind of considerations that you look at. But I can tell you that within TCAP and the structure right now, I think we provide very effective overall training and a kind of prosecutorial experience and arm for our prosecutors. So thank you for the question. Very good.
Colonel Kaysen, sir, the next question I think would be best for you up at OCJAG. How many court-martials did the Army conduct in fiscal year 2019? And how many did you see in 2020? Over.
Okay. So the great thing is these are numbers that are publicly available. So I don't have to give you any inside information. So if anyone ever wants to look up what the Army's yearly and the other services yearly courts-martial numbers are, go to jsc.defense.gov. That's where we post the annual report. Services are required to submit an annual report to Congress every year, and we include all of the numbers from courts-martials from that previous year, fiscal year. So fiscal year 2019, the Army arraigned 792 courts-martial cases. That's general and special courts-martial. And 630 were tried to completion. So the difference in those numbers, some of the cases might not have been tried to completion. They would have started in one fiscal year and carried over. Some of them may have had alternate dispositions. So FY19, 792 arraigned, 630 completed, which was actually an uptick from previous years. 2020, our numbers we kind of got thrown off by COVID-19. So there was a dip back down. There was 729 arraigned court-martial cases and 581 completed. Within this next fiscal year, we're catching up as many of the civilian criminal courts are also trying to catch up with the COVID-19 delays that were made in courts-martial. So we'll have to kind of wait and see from a data point of view whether or not the uptick in 2019 was a blip or a trend. The general trend over the last 15 years has been a reduction in the number of courts-martials from across the services. And so it just kind of depends on we're going to see what the future data holds. Thanks.
The next question, Colonel Swilley, you may, based on your broad level of experience, be able to address this one best. This is from Savannah Porter Miller, and she asked, where are the civilian prosecutor experts located? And at what point do civilian prosecutors meet with sexual assault victims or domestic violence victims? Are these the people that accompany the victim to file a criminal complaint in a civilian criminal court to show support? Over.
Okay, thank you. See if I understand. So the question is specifically about civilian prosecutions.
Yes, ma'am. And in particular, potentially where the HQEs and how did they help? Do they actually prosecute cases? And what is their role?
I may have to turn this one over to Colonel Staton or Colonel Farrell, who have a little bit more experience kind of with the civilian side of the prosecution piece. I know that at Fort Hood, we had a lot of interaction with, prosecutors in the state courts, and we worked closely with them, involving soldiers, but specifically kind of their procedures. I think probably Colonel Kazin might be a little bit better prepared to answer.
I think why Colonel
Speak to how
Hamilton.
we did it. I can definitely speak to how we've done it everywhere I've been. So if you're talking specifically about, the special victim prosecutors and the other people who are more expert level, as well as we have our civilian HQEs. So of course we only work within our system, but we met constantly with the civilian district attorneys as well as the U.S. Attorney's Office in the local jurisdiction. And that's a standard practice across the Army. And we will meet on cases. Often those cases are incidents, obviously, that they occur off post. So there's a dual jurisdiction issue. And I haven't ever been anywhere in the Army where it wasn't a very good relationship, where the prosecutors would sit down and talk about who is the best agency to handle this case. So do we assist them? Do we take things to them? Not really, because if they're involved, it happened in their backyard. Sometimes they bring it to us to talk about the case itself and decide what jurisdiction is most likely to be successful. And so many factors go into that. The size of the current docket at each place, how quickly you can move the case. And in our system, I can't remember if Colonel Hamilton mentioned this or not, but we have an obligation to meet with the victim and ask that victim, where would you like your case to be prosecuted? They don't control the decision, but their input and their request is incredibly important to us. So that absolutely goes into our discussion with a local district attorney about who should prosecute a particular case. We don't go to court with them. We don't take the victim. The prosecutor doesn't go and sit at the table or anything like that, but we are constantly in conversations with them leading up to trial. And Colonel Hamilton could probably add to what our SVCs do when victims have cases in civilian court.
Thank you, Rebecca. Right now, we do not authorize our Special Victims Council to participate in civilian courts in any fashion. However, through a few programs at various installations where one of the civilian attorneys that works in the legal assistance office, who may also be licensed in that particular state, there are some programs that allow the civilian attorney to accompany, especially in the realm of domestic violence, the domestic violence victim to the civilian court to participate on their behalf and get them into the system. However, the Army, we will not allow our SVC at present time to participate in civilian courts.
Excellent. Thank you, sir. The next question, Colonel Kazin, I think you're in the best position to start. That is, what do you feel are some of the pitfalls about the military functioning both as a discipline and a justice system concurrently, considering that some individuals may use NJP as a means to circumvent the court-martial process? Over.
Okay, thanks. So this touches on a little bit of what I talked about before about, I think that the dichotomy of saying that discipline and justice or discipline is simply part of the military justice system. If we take a critical look at the American justice system, it doesn't quite hold up. It's just how we think about discipline. When you think about using criminal law to control human behavior, telling someone they can't do something, and if they do it, you punish them, is no different than within the civilian context as it is in the military. So I think that this balance between discipline and justice is one that we have to look at both in the American criminal justice system and in the military justice system. In terms of the specific question about how NJP is used, I think I understand the question to be that the decision makers the commanders, with the advice from their lawyers, are using NJP to avoid having to use the court-martial system. I don't look at NJP or non-judicial punishment under Article 15 as being separate, because it's part of it. It's actually under the Uniform Code of Military Justice. It's an aspect of it. It's an option, similar to things like pretrial diversion in the civilian criminal justice system, where you look at the nature of the behavior and the sanction needed to ensure, not to do that behavior anymore, or to show the command or to ensure discipline is met through non-judicial punishment. I think there are some concerns. I think when commanders have to make that decision with the advice from their lawyers based on the facts of a particular case. I don't think that the use of non-judicial or administrative remedies undermines the court-martial system. It simply is different options to deal with it. In fact, I feel like we have more options than military, because in the civilian justice system, you really have a prosecution, non-prosecution dichotomy. Pretrial diversion is in there a little bit, but that's still, again, the prosecution is the stick to make pretrial diversion work. And in many jurisdictions, pretrial diversion options are fairly limited. Whereas I think that the vast amount of administrative remedies and powers that a commander has gives them a lot more options to deal with misconduct that don't necessarily rise to a prosecutorial level.
If I could add to that, Colonel Kazin, I think to maybe get at some of the concerns is it's not possible for a commander to use NJP to avoid a court-martial. Because first of all, a soldier is entitled to legal counsel when they're going to get an Article 15 or non-judicial punishment. So they go see a trial defense attorney about their case. The standard of proof is beyond a reasonable doubt, just like at a court-martial. So you have to have the evidence to get there. The third thing is there's a little block at the top of the form where they're asked when they come in to be punished, or they come in for the hearing, before there's any punishment, when they come in for the hearing, and it says, I decline and I demand, it actually says, I demand trial by court-martial. So the soldier can say, no thanks, you may not do this, you have to court-martial me if you want to get any discipline out of this case. So the soldier has so many rights in the NJP process that maybe one wouldn't expect, because it is seen as lesser than a court-martial. So I just don't think it's possible for a commander to sort of use it as an end run to a court-martial.
Hey, Scott, this is Lieutenant Colonel Staton. Just to add to Lieutenant Colonel Farrell, Lieutenant Colonel Kazin, if I could, I think it's also to remember the purpose of why Article 15 was created by Congress, and that was to address the uniqueness of the military justice system and preserving good order and discipline. And like Colonel Kazin said, continuous absences maybe from work, maybe on the civilian side, not considered the same within good order and discipline of a unit, where that service member is not showing up, and that could have a profound effect on good order and discipline and readiness. And so along the lines of the continuum, like Lieutenant Colonel Farrell was talking about, it's not necessarily just court-martial, but maybe lower levels such as counselings or a letter of concern have already been tried by the command, and that hasn't worked. And so the next thing to deal with it efficiently and quickly within the military justice system is through the use of an Article 15. Thanks.
Excellent.
And if finally,
Third.
Scott, if I may,
Definitely.
with regard to the end run that they talk about, always keep in mind, especially when you're dealing with a special victims case, that the victim may not want to proceed to anything greater than an Article 15 or an administrative disposition without having to be subjected to cross-examination on a witness stand.
Thank you, sir. And thank you to our entire panel for being here today. I see we are out of time. I will answer the questions remaining left in the chat. But with that, thank you for your time. Thank you for your questions. And thank you for being part of this today.